look at, it's a resolution of the Institute, and you look at Article 5. You have that. You also have the International Law Commission. You also have the Special Rapporteur. And what these three international treatises or whatever do is they tell your Lordship, having regard to Marcus, having regard to the Prince of Liechtenstein, the International Law Commission document, and the third one is the Special Rapporteur. So those are three, what we would call recognized international law treatises. However, maybe the pronunciation is wrong, and what they all say, and it's important why they say it and how they say it, they all say it's uncertain, and the conclusion that they come to is it's comity, not obligation. Your Lordship knows that. I made this point yesterday. They say it in terms, in clear black and white. And you have this, and the important proposition is this. When they do this, when these treatises do it, they look at Marcus, they look at Kilroy, they look at Prince of Liechtenstein, Prince Charles, with Kilroy is Prince Charles, Prince of Wales. And they say, this is what Prince Charles' case says, this is what Kilroy says, this is what Liechtenstein, this is what Marcus says. So that's what you've got on the one side. And that side says, it's comity, it's not international customary law. And what have you got on the other side? On the other side, you've got Mr. Epstein representing a particular client who takes the same authorities, Marcus, Kilroy, Liechtenstein, and he says it is. And I make a simple proposition at the end. Do you follow the Special Rapporteur, International Law Commission, and the Institute, or do you follow Mr. Epstein, my friend? You will decide, my lord, as it pleases the court. Excuse me, Yes, my lord. My lord, perhaps your Lordship should have regard to two aspects. The one is the fact that there were three amici is utterly irrelevant, because the amici don't support the applicant, they don't support the respondent, they're there to assist the court. And if they put up 1,000 cases, all happen to support the applicant, all happen to support the respondents, it's irrelevant for purposes of this debate. So what Mr. Epstein's client was faced with was, in fact, us versus him for purposes of costs. If you take our heads, and you look at our heads, and you see there's a list of authorities which is attached to our, it's page 37, 39, there's, I think there are 40 items. Then you take Mr. Labuschagne heads, far less authorities. And then what you do is you look at Mr. Epstein's heads, and your Lordship will be bold, your Lordship is bowled over by the authorities and the length. It goes way beyond anything that we produced. And we have to deal with that. They have 74 authorities. And you look at the authorities, 5 cases from the United States. It's the Kilroy case. Academic authorities that nobody's ever heard of. Switzerland. You look at the South African cases, 48 South African cases. The point is this. We have to deal with it. And I made the point to you yesterday where it was used. Because up to the point of Mr. Epstein's heads, we had 2. Only recently have we had a 3rd. So we're not asking for 3 counsel from the beginning, because we see this as a simple case. There are 3 propositions. 1, 7.2 is not the power. 2, it's not part of Custom International. And 3, 232, it wasn't for her to decide, it was for the court to decide. But here we have an argument with, we have to deal with it, as it pleases.
Had to do something. The Lordship will recall that we indicated that if there was an international customary, a rule of international customary law that spouses enjoyed the benefit of spousal immunity of the head of state, then that would have been the position which the Zimbabwean government could have asserted in the way they deem fit, whether they came to court for purposes of a declarative staying in the prosecution or whether it was raised as a defense in a trial. Nothing enjoined the minister to do anything. But she put a stop to the prosecution by whatever she did. And my client comes to court on the basis that what the minister did stands as a bar to her exercising her constitutional right to have a day in court on a criminal complaint.
But what happened is that your client agreed with the fact that this Zimbabwe had this invoked. Your client agreed that she may be granted. Your client didn't regard it as an invocation. Your client then wrote to her and said, should you consider granting immunity, we would like to make submissions because of the following. And then I don't think your client was given much. They weren't being heard and the immunity came through. So at that stage, everybody was working on the assumption that she's going to be granting it, that it didn't exist, that the Zimbabwean government hadn't invoked it. It is only subsequently, right at the end, that the minister comes to the conclusion, well, actually, she does have it. Although she takes into account a whole host of, and there's 9 other paragraphs, she comes to the conclusion that I had to grant it, that I was compelled to do so. Now, what did she do wrong with that?
Well, my lord, what
We all started wrong in the beginning. It's a request for the investigation. You're going to be considering it. You must look at our interests. We're all acting under this misguided view of what the issue is. And then she, in the course of dealing with this misguided view, comes to that conclusion, well, I'm granting it. I mean, I'm recognizing it.
I recognize that is so. Lord, what we submit is that my client, by whatever the minister did through that published decision, has put a stop to the prosecution proceeding. Your Lordship will recall the police were holding back pending a decision. That's the case. So my client is here to vindicate a constitutional right. And if that...
But is that right not still existed to your client in the light of Mr. Epstein's concession this morning?
And this is what I want to get to now. My Lord, my client seeks relief. That her right to pursue the prosecution is untrammeled by the decision of the minister. She seeks that to clarify. And our submission is, my Lord, that she would be entitled to it.
But isn't that's not the answer? Isn't this the answer? Your client, that is Ms. Engels, doesn't want to be going to a prosecution process and having this argument regurgitated.
Yes.
That's essentially the answer. I mean, it could still happen that because that decision contains 10 or 12 paragraphs, 9 of which seem to be irrelevant to the issue of whether she had it or not. 9 of which deal with whether it's in the interest, whether of the country, etc. The 10th one deals with whether she has it based on certain other international precedents.
Yes. But
your client will still have to deal with the fact that the defense would still argue, and that court would have to still deal with it.
No, my Lord, my client is before this court seeking a declarator. And my submission is, my Lord, that if the conduct of the minister is unconstitutional in that she invoked a statutory power under Section 7.2, that is an imperfect vehicle, in that it does not provide legality for the act that she was exercising, then that is unconstitutional. And under Section 1721A, this court must declare it invalid. The only issue arising from what Mr. Epstein says is what would the just and equitable remedy be flowing from such a declarator? And there the question of mootness is perhaps incorrectly being raised because it's really a question whether your Lordship will exercise a discretion to do nothing. It's not a mootness issue, it's a question what is just and equitable under Section 1721B. And in that context, my Lord, our submissions are that when one looks at what our learned friend has conceded, two things must be borne in mind. Firstly, it is a concession of law that is not binding on my client, not on the court either, and if wrong, can be retracted. It is for the court to determine what the legal position is, and my client is an applicant for a declarator on that very issue. And we submit, my lord, that there is no reason why my client should not be granted the relief that the decision of the minister, which has two legs, it's under 7.2, and it recognizes a customary international law rule, is wrong in both respects. The just and equitable remedy would be to state that the minister's conduct is to be set aside because it was based on an imperfect vehicle, a provision that doesn't empower her to take a decision to recognize when she's given a power to confer immunity. And secondly, that the issue of whether customary international law recognizes spousal immunity, that in itself is an error of law. Now, my lord, getting to the question of, but what if there was such a rule, if there was such an immunity, and it has lapsed? My lord, there's a temporal argument that I wish to develop, and if I can cut to the chase, my lord, the proposition is that there is no clarity on the issue of whether immunity which applied in a specific time period falls away for acts perpetrated during that time period. When it comes to DIPA and the Vienna Convention, I'll point your lordship in a moment to a provision that says that the immunity lasts for as long as the diplomatic official is within the country, but it persists even after he has departed in respect of acts done during the course, during that time period. So, my lord, to say that the immunity has fallen away means, in our submission, that if Dr. Mugabe comes back and assaults someone again, she would not have immunity. But it doesn't answer the question whether she can say that at the time, I have a government gazette saying that I have immunity, comes from the minister, and it's binding on the criminal court. It hasn't been set aside. So, my lord, we say it remains that temporal argument of whether the immunity during that time period persists, isn't addressed in the concession of my learned friend. That is a matter of law. And if I could just make two submissions then on why we say that the indicators is that temporal component of the immunity that persists is part of international law. There are two bases on which we say it. The first is on clause 39.2 of the Vienna Convention, which I've just paraphrased to the court. It says when it comes to officials, if we could just refer to it, Lord. I've provided your lordship with a copy of that act. In the convention, Article 39, it says in subclause 2 that immunities shall normally cease at the moment when he leaves the country or on expiry of a reasonable period in which to do so, but shall subsist until such time, even in case of armed conflict. However, with respect to acts performed by such person in the exercise of his functions as a member of the Commission, immunity shall continue to subsist. So that temporal component, and this is a codification of international law. As far as diplomats and their families are concerned, that would be the position. In the Marcos case, the court stressed that as a matter of Swiss law, a spouse enjoyed derivative spousal immunity during the state visit where she accompanies the head of state. It doesn't speak of whether it persists or anything else. Our submission is, my lord, that if one has regard then to the position of diplomats, is there anything that suggests that Dr. Mugabe would not be able to raise her immunity for acts perpetrated during the period that she enjoyed an immunity through the act of the minister? And our submission is, my lord, the court needs to pronounce on it.
But does it really apply? I mean, Article 39 is talking of acts performed by such a person in the exercise of his functions as a member of the mission.
Yes.
So what acts we are talking of?
We're dealing, my lord, firstly, with a spouse of a head of state on a private visit.
As a member of a mission.
No, my lord. The fact that the minister turned it into spousal immunity. The application by Zimbabwe was initially that she was a special envoy, but she was treated by the minister as the spouse of a head of state. But in circumstances where she was not accompanying him and was performing a private act.
Now that's what I'm referring to.
Yeah,
so my point is, the immunity she got is not the immunity they're referring to.
That is so.
The immunity they're referring to is immunity received for acts performed while you are a function of a member of the mission. That immunity subsists even after you've left. But the immunity she receives, in terms of international customary law, comes to an end.
Lord, we submit that there is no support on what we could find for that as a proposition of law. And before
that
the court,
is stated in all the...
No, my lord,
I think in every... I thought it's common...
My lord, I'd like to stress, it is not common cause from my client.
Oh, it's common knowledge. But
yes.
Look behind you, they agree with me.
My lord, with this,
Counsel for full
yes,
are nodding their heads saying, I'm right, but anyway.
we submit, my lord, before the court...
I thought you agree with them, but never mind.
With respect, because this temporal issue, whether the immunity during the period that it existed,
does it persist?
Does it persist or does it not? And that is the issue we say this court should rule on, because we submit that.
But isn't that settled law? But isn't that settled law?
My lord, with respect, if the Lord Court finds, your lordship finds that it is settled law, then we request your lordship to state that law. But to assume it based on consensus between the parties before you would not be correct as far as my client is concerned.
Okay, thanks, I've heard you.
That is the issue.
Thanks.
So the issue of mootness, we say, remains a live controversy, and to avoid dealing with it will leave open the door to raising the immunity argument at a criminal prosecution should that ensue, and we request the court to come to my client's assistance in granting just and equitable relief under section 1721B, which we submit requires a setting aside of the minister's decision and the declarator as sought in the notice of motion. My lord, we make common cause with the submissions of Mr. Katz on the issue of reading in. It's not a competent remedy before this court because there's no constitutional challenge. And reading in is a remedy flowing from a declaration of constitutional invalidity, which is not being pursued in these proceedings. My lord, as far as our learned friend's reliance on case law is concerned, we wish to make a few short submissions, my lord. And this would really just be with reference to our learned friend's heads, the cases that they refer to from paragraph page 37 onwards. We'll be dealing with three of those cases. The first two are grouped together. It's the Kilroy case, the Prince of Wales case, and also the Klein and Kaneko case. Now, in fact, there are two Klein cases, Lord, but they both confirm an American practice. The reference I would like to provide to the court in the Kilroy case is in the authorities bundle, page 6656 to 7. And in the Klein case, page 6511. Why we give these references, my lord, is because they indicate that in the United States, that covers both those cases, the diplomatic immunity starts with a request from the foreign state, goes to the Attorney General, who then considers the issue, and if satisfied that such immunity exists, writes a suggestion of immunity. That's the document, that's what it's called, and that is filed with the criminal court or the court concerned. Now, the filing of the suggestion of immunity binds the court. And the references I've given to your lordship, particularly page 6511, indicates that the reason why this process is followed and why they assess it is to preserve the international relationship between states. So that it is a discretionary issue based, we submit, on comity. And that applies to the American approach. Although they will use words speaking of customary international law, their process indicates, and the case that we've referred to indicates, that it's based on decisions aimed at preserving the foreign relations between the countries. My lord, the Marcos case, I've just indicated, applied to a visiting head of state and his wife and her immunity under Swiss law during the period of the official state visit. It's distinguishable on the facts. All of this points further to the fact that when one is seeking widespread usus, it is not to be found. And where one finds it, it's based on comity and not on customary international law. My lord, as a last consideration, I'd like to refer the court to the Foreign States Immunities Act. If I could hand up a copy. And this is an issue dealt with by our learned friends, in paragraph 110 of their heads. And to place the submission I'm about to make in context, it's about section 232 of the Constitution, my lord. Your lordship, we have heard, you've heard the submissions from the amici on why, firstly, there isn't such a rule of customary international law, and secondly, that it would be unconstitutional if there was one. What we would like to add, my lord, is an issue of rationality, on what, and it is based on national legislation as being contrary to national legislation. Now, look, the context is firstly that this Foreign States Immunities Act of 1981 deals with the immunity of foreign states, but in the definition of a foreign state, a foreign head of state is included. And if your lordship has regard to section 1, subclause 2, it just makes it clear that when the Act speaks of a foreign state, it also includes a reference to the head of state, in his capacity as head of state. I immediately stress, my lord, that this Act is not going to speak about the spouse. It will speak of the position that President Mugabe would have had under this Act. Section 2.3 of that same provision provides a procedural bar to criminal prosecution of a foreign head of state. So President Mugabe could not be brought before a criminal court. But, my lord, when it comes to circumstances under which immunity could be granted, there's a very specific provision that the other parties have not referred to. It's section 6. Our learned friends, Mr. Epstein and them, have referred to section 2 as though that would establish some form of usus. But what we wish to highlight, my lord, is substantive immunity. In other words, instances in which immunity can be granted to a foreign head of state in terms of national legislation in this country. This act specifically has a provision which says that a foreign state shall not be immune from the jurisdiction of the courts in proceedings relating to the death or injury of any person caused by an act or omission in the Republic. And why we raise this, my lord, is that if the perpetrator of the act against Ms. Engels had been President Mugabe, then under this section 6, he would not have qualified for immunity as foreign head of state, but could in any event not be brought before the court because of section 2.3 of the Act. Now, my lord, can Mrs. Mugabe have a derivative spousal immunity under national law that exceeds that of the head of state? As a matter of rationality, no. If her immunity is derivative, it cannot exceed it. And if the President of Zimbabwe could not, under section 6, have qualified for immunity relating to the injury of Ms. Engels, then as a matter of rationality, how could the Minister recognize a law, a customary international law provision that ostensibly conflicts as a matter of rationality with national legislation? We add that to the considerations for the court as to firstly why there is no international rule, customary law rule pertaining to derivative spousal immunity, and secondly pointing to an irrationality argument based on the second leg of section 232 of the Constitution as to why it, on the face of it, would not only be unconstitutional for the reasons advanced by the Comity, but irrational based on section 6 of the Foreign States Immunities Act. That concludes my submissions, unless there's something specific the court requires me to deal with.
Thank you. You asked me for cost of two.
Counsel.
Thank you very much for all your submissions.
1 minute to correct something that
Yes,
was said
Mr.
concerning what was described as the concession. Your Lordship asked yesterday what the Minister's view was as to whether immunity persists. I took instructions, we gave advice as to what the law is. And it's described as a concession. It was never the case of the applicants that the immunity still persists. It always concerned the recognition of immunity at that time. And all we have told your Lordship in response to your Lordship's question is that the Minister's view is that as a matter of law, the immunity does not persist. And I say that, my Lord, because the matter may well be reported differently if reference is made to a concession, which my dictionary tells me means to acknowledge as true, just, or proper, to admit, to acknowledge an opponent's victory before it is officially established, to grant a right or privilege, to make a concession, yield to pressure or circumstances that admit defeat. It's not a concession, my Lord. It wasn't their case. And it was in response to what your lordship put to me, and it's not, a matter of law cannot be a concession.
Yes.
It's a matter of law.
You just merely stated what the legal
I simply state
position
that.
is.
Lord, there were some of our cases which were not put into their bundle.
Please
It's a
keep
short
them.
bundle. May I hand them to you, Lord?
Please. It's very difficult to find some of this stuff. Anything else? Do you know the date at which President Mugabe lost?
No, but
his-
I'm sure we can Google it. What did they say?
Somebody was supposed to do that yesterday.
Well, if I understand it correctly, and I've got the African Forum papers, but I'm told
Foreign states.
November, it is in November. In our head, we
No,
put in
but the
November.
actual date,
152. I think it's page 152 of the African Forum. Yes, paragraph 4, I wrote that. Of the African Forum papers.
papers.
Paragraph 4 of the page 153 of the African Forum papers. And I think it's the 14th of November. Yes, I'm told.
Lord, Mr. Labuschagne dealt only in reply with the Foreign States Immunities Act. We deal with it in our heads of argument, page 110. It relates to civil claims, and it doesn't apply, and it excludes criminal jurisdiction. It's paragraph 110 of our heads of argument. And to be read, my Lord, with paragraph 42 of the Al-Bashir judgment.
Paragraph?
42 of the Al-Bashir judgment. Does not apply here. Thank you, my Lord.
You're talking about the share, this SCA or
Yes. Yes, ma'am.
the SCA judgment?
Yes.
Thank you. Thank you, everybody, for your time. Judgment will be reserved. You'll get a written judgment in due course. When, I don't know. But you'll get it hopefully soon. I don't know. I'm not committing myself to any specific time, but you will get a written judgment.